At a time when the university budgets are in crisis mode, it really gives us a lot of satisfaction to know that there are many supporters for debate at Iowa. And so we'll try to reward that confidence in our group as we debate the question of whether the United States federal government should develop a national standard for the use of force and abolish qualified immunity to regulate the conduct of law enforcement officers. I think we all know that Black Lives Matter. Trayvon Martin, Laquan McDonald, Tamir Rice, Michael Brown, Philandro Castile, Ezell Ford, Stephen Clark, Sandra Bland, Eric Garner, Dre'Shaun Reed, Ahmaud Arbery, George Floyd, Tatiana Jefferson, Breonna Taylor. These are just a few who were Black victims of police violence. This year of COVID-19 is also the year that more and more people have spoken out against policing practices that evidence racial bias and involve the excessive use of force. So tonight seems an appropriate time to consider whether the federal government should respond to these concerns by developing a national standard for police use of force and abolish the defense of qualified immunity by police officers. Now, when incidents like this have happened in the past, the federal government has investigated claims of racial bias and excessive force and negotiated consent decrees with local police. Promises were made about reforming training and supervision, but they've been ignored in practice. Militarization of police tactics using weaponry from war surplus has also made it more difficult to hold police accountable. Now, at present, state and local governments and police departments are primarily responsible for setting standards for the use of force. When police officers are accused of using excessive force, civil, criminal, and administrative penalties are possible, but infrequently applied. The legal doctrine of qualified immunity was developed by the U.S. Supreme Court under Chief Justice Burger. It gives police officers a defense against civil liability for their actions unless those actions violate law clearly established by specific facts and legal precedents. The qualified immunity doctrine works to exonerate police, however, when the standards are not clear. Criminal punishment and administrative discipline are constrained by the politics of justice. Prosecutors and attorneys general are hesitant to bring charges, and trial juries often give police officers the benefit of the doubt. Police unions pressure police departments to allow officers who have been suspended to apply for jobs in other places without carrying their previous records with them. Well, tonight, 4 distinguished alumni of the University of Iowa will debate whether the U.S. federal government should develop a national standard for use of force and abolish qualified immunity to regulate the conduct of law enforcement officers. Arguing first for the proposition will be Dr. Carla Leeper of the class of 1985 from Augusta, Georgia. Carla earned a PhD in speech communication and rhetoric from the University of Kansas and an MBA from Augusta University, and she's currently the Executive Vice President for Operations at Augusta University AU Health. Arguing second for the proposition will be Professor Corey Rayburn Young of the class of 1999 from Lawrence, Kansas. Corey holds a JD from the University of Virginia School of Law. He is currently William R. Scott Research Professor at the University of Kansas School of Law. Arguing first against the proposition will be Andrew Peterson of the class of 2001 from Arlington, Virginia. Andy earned his law degree at New York University and holds an MA from the Johns Hopkins School of Advanced International Studies. He worked for a number of years in government at the CIA, the Department of Justice, and the U.S. House of Representatives. And he's currently a member of the law department at the Boeing Company. Arguing second against the proposition will be Andrew Ryan of the class of 2001 from Dallas, Texas. Andy earned his law degree at Baylor University School of Law and achieved immediate success in the practice of law, becoming a partner in record time. He didn't say that, I did. Recently, he co-founded a law firm specializing in white-collar defense, investigations, commercial litigation, and the healthcare industry. Each speaker will present a 5-minute opening speech. Following each of those opening speeches will be a 3-minute period of questions from the opposing side. Then each speaker will have 4 minutes to summarize her or his final position. The affirmative will begin and the negative will end the debate. And I guess we'll have a period for questions at the end. So let the debate begin. You're on the side of truth.
All right. Well, Dave and Paul, thank you for giving me the opportunity to participate in this debate. It's always great to reconnect with the Hawkeyes, and I can truly say that I do not know where my life would be if it were not for the opportunities that I got in Iowa debate. It's been a long time since I've actually been in a debate, 1985. We had a Republican president who was controversial. We were terrified of the Russians. The economy wasn't doing very well. And I was in a debate round with David Hinksman, who knew more about the topic than I did. So what comes around goes around. And I think we're pretty much where I left off. So with that, I will start the 1AC. Last Saturday, Jonathan Price stopped on his way home from work to try to break up a dispute among neighbors. Responding Wolf City, Texas police officer Sean Lucas used his taser on Price and then shot and killed him as he attempted to walk away. Price had moved back to the neighborhood because he thought he could make a contribution. Officer Lucas has since been charged with murder. Unfortunately, while we are horrified, we can no longer claim that we are shocked by these displays of excessive force. This is why Corey and I affirm the resolution. Resolved, to regulate the conduct of law enforcement officers, the United States federal government should develop a national standard for the use of force and abolish qualified immunity. I will offer the case for a national standard, and my partner will address the abolition of qualified immunity. More than 1,000 people are killed annually by the police in America. Nearly 60% of those who are lost are like Sean Lucas, unarmed and unjustifiably victimized. A disproportionate number of them are people of color or people who are mentally ill. The claim that the misuse of force is rare is just not accurate. USA Today obtained data detailing at least 200,000 incidents of alleged misconduct and almost 23,000 investigations of officers using excessive force. Independent Department of Justice probes into police departments in Ferguson, Baltimore, New York, and Chicago revealed agencies that routinely and brutally violate the rights of residents. And it is likely that other incidents can be found, at least to some degree, in a majority of the 18,000 police departments around the country. Despite a number of high-profile murders and public protests, the states have been unable to muster the political will to act. As of 2020, only about a third of states have passed laws regulating police use of force. The lack of such legislation means that too often the courts are left to assess police conduct after the fact, after shots have been fired, and after detainees have died. In a nation that was built upon the rule of law and that in normal times, okay, and I'll give you in normal times, has a robust system of checks and balances, we cannot allow an entity with the sweeping powers of the police to remain one of the least regulated. The 14th Amendment to the Constitution gives the federal government the authority to act to preserve the constitutional rights of individuals if the states are failing to protect them. The constitutional standard asks only that the proposed remedy be congruent and proportional to the constitutional violations that Congress seeks to address. There can be little doubt that the historic pattern of the use of excessive force against people of color and the mentally ill rises to the level of a violation of due process and equal protection, and creates a strong presumption that the creation of federal standards on use of force would be congruent and proportional. The development of a federal standard has clear benefits for the citizens and for the police. The establishment of federal guidelines that are well understood, consistent, and that outline what constitutes professional and acceptable conduct for police officers will improve police decision-making during critical incidents, give the departments the tools to rid the ranks of the bad apples, save lives, and protect liberty. Clear protocols developed under the standard can serve as consistent references for courts in civil litigation, improving the outcomes of those decisions. The process of creating federal standards could provide a framework for responsive and democratically accountable community collaboration, which might facilitate additional reform. And finally, police forces compelled to police themselves aggressively might well find better community relations on the other side. In communities where relationships between the citizenry and the police are strong, the job of the police gets easier, not harder. The culture of police departments has long been a barrier to police reform at the state level, and the special interests involved in policing should not be underestimated. But Congress has powerful leverage in overcoming these cultural barriers in departments and communities by making adherence to the standards a prerequisite for federal funding. They've done it before, they've effected change, and it would work in this instance. A national standard for the use of force is not a radical concept. The federal government provides standards of conduct for a number of professions when there is a compelling national interest. The FAA certifies pilots. The FCC certifies persons operating and repairing radio transmitters. The EPA requires that technicians recycling Freon be examined and certified. Shouldn't we care as much about maintaining clear and consistent standards of conduct for police as we do for the pilot who flies your plane, or at least for the technician who fixes your refrigerator? We stand in support of the resolution.
Hey, Carla, I'll be doing the cross-examination. You finished up talking about, oh, let me turn my timer on here, even though I know Brian's doing it. You talked at the end that there are other federal standards of conduct that are enforced, like those of the FAA. Does the FAA certify, when they certify pilots, exactly how the pilots are required to respond in an emergency situation?
Well, I do think there are standard accepted practices of behavior for which they are judged. Protocols.
So for instance, when there is a crash, how are the pilots judged against those protocols?
Well, I believe that the way they're evaluated is they look at the circumstances and they ask, in that set of circumstances, did you exercise the kind of judgments that we expect a professional in those circumstances would judge? So, if you're in a flight simulator, right, it sets up certain standards of behavior. And if you deviate from those standards of behavior, I suppose they would be able to make an argument as to why. But in general, there is a standard of behavior. Physicians have the same thing, right? There's a standard of care that's expected for patients, even though patients are different.
So do you think that there aren't any standards for law enforcement right now? What's the difference between a standard that exists now at the state and local level and the one that you've proposed creating at the federal level?
Yeah, I think that's a great question. I think what ends up happening is, depending on the culture of the police department, there are standards that are inconsistent, that are various, that might be influenced, not by best practices, but by the attitudes of the officers who are in that particular department. So, chokeholds is a great example. A lot of departments have eliminated those, but not all of them, right? And there's no argument as to why a chokehold is a best practice. So the federal standard would create some consistency among some of those most egregious examples.
Well, that assumes that we can reach a federal consensus, doesn't it? I mean, you alluded to the fact that in your intro that we're, divided as we were in 1985. Why do you think that even if we task the federal government with developing a national standard, that what will come out of that process is kind of a unified agreement about what that standard should be?
Yeah, look, you're not going to get everyone on board, but at the end of the Obama administration, they came up with a pretty good list of things that were, good guidance for police departments, good guidance for practices. They made a lot of headway. I think it is likely that we could, at a minimum, get to a better situation than where we are today. And I think we could start with those items where there would be broad consensus, like chokeholds, and work from there.
All right, I've only got about 5 seconds left, so I'll end it there, Carla.
Thank you.
Good evening, everybody. My name is Andy Peterson, and along with my partner, Andy Ryan, we will be arguing against the resolution that Carla so ably described. I want to thank everybody for participating in this event, and it's timed perfectly because my children are walking in the house right behind me, so you may hear some scuffling or see some things behind me. But I also want to thank you for your ongoing support of the A. Craig Baird Debate Forum and Iowa Debate. Like Carla, I can say with certainty that none of the people participating in this debate today would be where they are without Iowa Debate. Although I guess that means Dave and Paul owe an apology to all the KU law students out there. Sorry, folks. First, and so I'm going to be focusing, like Carla, on the establishment of the national standard for the use of force and leave qualified immunity to Andy. But none of what Carla just described, none of the tragedies she listed, none of the incidents of officer misconduct, none of it would be actually resolved by a national standard. You know, the United States has repeatedly talked about creating standards, enforceable standards, widespread standards for law enforcement before. A presidential commission known as the Commission on Enforcement and the Administration of Justice recommended the development of such standards. The president who created it was Lyndon Johnson, and the year was 1967. And actually, there is an identically named commission now created by the current Attorney General, and it will likely make similar recommendations that are equally ignored. Encouraging national standards is not novel, it's not new, and as Carla's discussion demonstrates, like Corey's efforts at graduating from Iowa, it has a long history of failure. Of course, it's possible this time could be different. You know, things could change. So let's look at the standard that Carla and Corey have recommended. Let me check back from my notes for the 1AC. Wait a second. I can't find it because they actually didn't recommend a specific standard. Carla argued for a standard that is well understood, consistent, and that defines what constitutes professional and acceptable conduct for police officers, and that such a standard would then provide a clear benchmark for other things like civil litigation. But the problem is that no such standard exists. We've been looking for it for 50 years. Now, I can say it'd be a good idea for Bellis and I to run a sub 3-hour marathon, but just saying it will not make it happen. It's a goal, not a concrete solution. One reason that we haven't made more progress in the past 50 years is we keep looking in the wrong place for a solution. Even if the government can agree, the federal government can agree on a standard, and even without that 50-year track record of failure, I have serious doubts about our current government's ability to agree on anything, let alone something as difficult and controversial as this. When the federal government has to find a standard that works in all 50 states, law enforcement environments that go from downtown New York City to rural Alaska, what you end up with is the lowest common denominator. If a solution is new or different, but cannot work everywhere, it is necessarily rejected. Indeed, what we need instead is local governments or state governments, but preferably local in my opinion, to begin to implement new standards, to stop relying on the idea that the federal government will come up with a one-size-fits-all solution, and to actually act like the laboratories of democracy that Justice Brandeis famously described. And now is especially not the time for the federal government to try and take charge. Change at the state and local level is beginning to happen. Many local and state governments are beginning to grapple with the issues created by their own police departments and the standards of conduct they use. They're evaluating those actions, trying to develop solutions, and that's what people are calling for, local change. What we don't need is for the federal government to short-circuit that process with a pre-packaged solution that will, like every prior national effort, fail to make a significant difference. Carla made the argument that federal leverage is necessary to overcome the cultural barriers, which I mean to take local political opposition, at state and local levels. But no standard, especially one that has not even been articulated, can lead to a cultural shift in policing if it lacks political support, especially when Carla and Corey have offered no data that any standard will make a difference. A better strategy is to let state and local governments continue to make progress, and those standards that demonstrate success will come to be more widely adopted. That's more likely to lead to lasting change than to try to enforce a one-size-fits-all standard. And at bottom, the only evidence about national standards demonstrates that to date, they have failed. There's no reason offered by the affirmative that this time will be different. We should reject a one-size-fits-all solution and allow local governments to continue to address these problems in ways that are best for their communities. And when workable standards are developed, we can then seek to try to enforce them, rather than put the cart before the horse. Thanks.
Carla, are you cross-examination, I think?
I thought it was you, but
Oh, I thought we were supposed to do our other person. See, we've obviously got this down. Like we were doing issue separation.
No.
Hey, Ryan, do you remember here?
So AP and I talked about it, and we just decided you guys are scared to cross him. So whichever one of you wants to do it is fine.
all right, let me have him. So this great laboratory of democracy of the states, to quote John Pope, and I never quote John Pope, how's that working for the coronavirus?
There obviously with state and local solutions, there will be issues, but the big issue that I would identify with coronavirus is that is something that requires resources at the federal level, when what you are talking about is just a standard that someone has to meet. That's something that does not require necessarily resources to implement. There's obviously training resources that go into it, but those exist in the status quo. And it is better because those communities are diverse. What our argument is that communities need to tailor those standards to their local situation. That rural Alaska does not have the same standard that New York City does. And so you need that local buy-in to make that standard effective for the community.
So just go back to the chokehold argument. Are you saying that in Alaska, you probably need a chokehold, or you might need it in New York City?
No, well, to be honest, I don't know exactly what those situations are. I mean, one of the difficulties I think that's happened over the last 50 years is the situations that law enforcement can encounter are incredibly diverse, right? Like people keep coming up with ways to do strange things, and we keep sending law enforcement officers in to try to deal with those things. And so that's why community engagement in the process about how law enforcement should respond is so important. And that when you put that at the national level, it necessarily short circuits a huge amount of that community engagement. Because yeah, there will be some people from across the nation on a national commission or whatever, but it's nothing like the amount of engagement that can happen at the local level.
So how do we overcome situations in communities where there is institutionalized systemic racism? You know, the federal government intervened some years ago to stop lynching. They've intervened at moments in our history when the local, state and local governments were just not getting the job done. And so I guess my question is, you know, how long do we wait for those communities to kind of get their mind right on some of these diversity questions?
Well, we don't necessarily have to. I mean, the Justice Department, the federal Justice Department has an entire division that's designed to enforce civil rights laws and also to investigate policing that's not effective. Now, you know, it would be a whole separate debate about whether or not and how effective that has been over time. But I don't think a national standard will make it more effective. And in fact, you know, the argument we're making is that that national standard can undermine those local efforts that are going on that we think will be more fruitful.
And all of those enforcement efforts, though, are after the fact, right?
Well,
preventive.
Correct, but that's true for any standard in the sense that all the standards that we're talking about, you know, if you violate the standard, it's always going to be an after the fact enforcement action to determine it. Now you train to the standard, right? So the training portion of that is the attempt to get it before those things happen, but violations of the standard are necessarily done after the fact, whether it's local or national.
Mm-hmm. And I think just the last question that I would have for you is, you know, you mentioned the nature of the sort of ongoing question of, you know, LBJ and Obama and this administration. You know, one of the things a national standard might do is to sort of address the politics at the national level. You know, we don't continually reopen pilot training and all that sort of thing. You know, I think even you would admit that there's inconsistency in enforcement of the rules that you talk about at the federal level, depending on who's in the White House or who's leading the Justice Department. So those, you know, relying on that is not a perfect solution to backstop the states.
Right. Well, I do think there's inconsistent enforcement, but I think that problem persists even if there's a national standard, right? The idea of, and the problem with that political moment is when you don't set out what the standard is, but just say we should drive to it. Our view is that that political divisiveness at the national level will inherently politicize a process where in a local community, you are not going to have the same level of partisan disagreement. I mean, we all live in a uniquely partisan time, probably not uniquely, but certainly in my lifetime, a acutely partisan moment. So I won't say it won't exist at the local level, but I think it can be much more productive when you stick to what the community wants, as opposed to trying to horn everybody into one solution.
Thank you.
Well, thanks for everyone for coming out and watching this event. It's very surreal for me to be doing this again at my old age, according to Andy and Andy. But it's great to see so many faces, or at least names, on the Zoom for those of you who are video shy. Also, hi to my kids, Torrin and Tegan, who wanted to watch, so they're in there somewhere as well. Unlike Andy, I don't need to shield my kids from my talking, so I'm actually proud of the arguments I'm making and don't have to be so shameful. So it's great to see you all, and I'm so happy to see Dr. Dave, and eventually we will celebrate your retirement. I know COVID will someday pass, I hope. So with that being said, it's great to do this, and I'm going to start the 2AC. I'm going to be talking about qualified immunity. Oh, hold on one second. I'm just going to make sure I have time here. I don't trust Brian. I don't know. We haven't met before. So yeah, let's get going. Just a couple of months ago, Judge Carlton Reeves, a federal district judge from the Southern District of Mississippi, began his opinion in Jamison v. McClendon as follows. Clarence Jamison wasn't jaywalking. He wasn't outside playing with a toy gun. He didn't look like a suspicious person. He wasn't suspected of selling loose, untaxed cigarettes. He wasn't suspected of passing a counterfeit $20 bill. He didn't look like anyone else suspected of a crime. He wasn't mentally ill and in need of help. He wasn't assisting an autistic patient who had wandered away from the group home. He wasn't walking home from an after-school job. He wasn't walking back from a restaurant. He wasn't hanging out at a college campus. He wasn't standing outside his apartment. He wasn't inside his apartment eating ice cream. He wasn't sleeping in his bed. He wasn't sleeping in his car. He didn't make an improper lane change. He didn't have a broken taillight. He wasn't driving over the speed limit. He wasn't driving under the speed limit. No, Clarence Jamison was a black man driving a Mercedes convertible. As he made his way home to South Carolina from a vacation in Arizona, Jamison was pulled over and subjected to 110 minutes of an armed police officer badgering him, pressuring him, lying to him, and then searching his car top to bottom for drugs. Nothing was found. Jamison isn't a drug courier. He's a welder. Unsatisfied, the officer then brought a canine to sniff the car. The dog found nothing. So nearly 2 hours after it started, the officer left Jamison by the side of the road to put his car back together. Thankfully, Jamison left the stop with his life. Too many others have not. The Constitution says everyone is entitled to equal protection of the law, even at the hands of law enforcement. Over the decades, however, judges have invented a legal doctrine to protect law enforcement officers from having to face any consequences for wrongdoing. This doctrine is called qualified immunity. In real life, it operates like absolute immunity. Tragically, thousands have died at the hands of law enforcement over the years, and the death toll continues to rise. Countless others have suffered from other forms of abuse and misconduct by the police. Qualified immunity has served as a shield for these officers, protecting them from accountability. This court is required to apply the laws stated by the Supreme Court. Under the law, the officer who transformed a short traffic stop into an almost 2-hour life-altering ordeal is entitled to qualified immunity. The officer's motion seeking as much is therefore granted. Every scenario described at the beginning of Judge Reeves' opinion corresponds to a real story where police violated somebody's constitutional rights, most of the time using deadly force, and in many cases, killing the person. But the doctrine of qualified immunity served as a shield to protect those officers from any accountability or civil liability for their wrongful actions. A little bit of history helps understand why qualified immunity is so important as a means of preventing accountability by police. In response to state-sanctioned violence against African Americans in the post-Civil War era, Congress enacted the Ku Klux Klan Act of 1871. It provided that every person who, under color of law, who subjects or causes to be subjected any citizen of the United States or other persons within the jurisdiction thereof to deprive any rights secured by the Constitution shall be liable to the party injured in an action at law. That statutory language captured in what's called Section 1983 is the basis for every federal lawsuit against police for unlawful use of force. The promise embedded in the Ku Klux Klan Act was broken in 1967 when in Pearson v. Ray, the Supreme Court reversed decades of precedent and invented the doctrine of qualified immunity whole cloth. Since then, the Rehnquist and Roberts courts significantly expanded the protection of police officers and made lawsuits against police virtually impossible to bring in a large majority of cases where police violate a civilian's constitutional rights. The tragic ending of the excerpt that I read from Judge Reeves' opinion is that he ultimately felt obliged to apply the existing morally bankrupt qualified immunity doctrine and grant protection and summary judgment to the police, even as he recognized the systemic and ongoing problems that exist. This same scenario plays out thousands of times every year in courthouses across the United States. Thousands more cases are never brought because lawyers will not bring lawsuits when the claims are completely unwinnable under existing law and doctrine. This has to stop. Qualified immunity is an obscene, unprincipled doctrine, and it has no place in a free and democratic society.
Corey, you said that qualified immunity makes winning civil lawsuits absolutely unwinnable, right?
Well, 99% of the time, yes.
Okay, and so that 99% of the time, that would not apply to Philando Castile, whose family was paid $20 million by the city of Minneapolis, right?
Well, not necessarily. Settlements are often done for reasons that have nothing to do with the winnability of the lawsuit, but simply because of public relations.
I see. So when the settlements are done, that's not because qualified immunity is not a good defense. That's for political reasons. But when lawsuits aren't brought, you can assume that that's because of qualified immunity?
No. There's many times that the suit is winnable. But since Pearson v. Callahan was decided in 2009, the standard is that the facts of the particular case which the lawsuit is based have to almost exactly mirror a prior precedent with the exact same facts. And that simply doesn't happen, which means any new way that police, even by minor variations, abuse or deny people rights, there's no basis for action. And Pearson v. Callahan...
So hold on, even though you say that, one of the people that I know you've read, because you and I have both read her, is Joanna Schwartz in her article in the UCA Law Review, right?
Mm-hmm.
So Schwartz discusses a study where when you actually analyze dismissals of civil cases based on qualified immunity, there's different ways to interpret the statistics, but on the low end, it's about 2% of dismissals, and on the high end, it's about 29%, right?
Yes, of cases
so that's
that are
not
brought...
absolutely unwinnable. I mean, if you have a 70% chance of winning, that was the chance that Hillary had of winning the election. How did that go?
That's called a selection effect, meaning the cases that actually make it into the system and then reach the appellate court level, which is what the Walker and Neeson study's about, those are just the iceberg tip, and everything else is underwater and you're not seeing it. The amount of police abuse versus the number of lawsuits that are actually won, the ratio is ridiculous. And there's no other area of law that has this protection for defendants. Qualified immunity is insane.
Well, all right. So let's go back to something, though. Carla made the point in the first affirmative that one of the things we want to do is have a national standard of care, right?
Not standard of care, standard of force.
Well, she analogized it to a standard of care, but call it what you will. If a police officer complies with that national standard of use of force or national standard of care, shouldn't they be entitled to some immunity from claims for police misconduct?
Well, so under any general tort, you have a negligence theory which holds somebody's liability based on the standard practices and norms. That's exactly why you don't need qualified immunity. Qualified immunity only kicks in after we all agree there's been a rights violation. If there's no rights violation based on some negligence standard which is used under Section 1983, it's a superfluous doctrine in those cases. It only does work when it protects bad cops from abusing civilians.
You're a law professor, I'm a lawyer. You and I both know that before the judges get to decide that, there's a substantial amount of money spent on people like me, right?
Well,
to defend cases and to argue that they should be dismissed.
Well, but there's a massive power imbalance here because police are indemnified, they get lawyers, plaintiffs almost never can get good representation in these cases because the odds of winning are so low. They have to take it on contingency with often very little representation.
All right, but the indemnification issue, that's not resolved by abolishing qualified immunity, is it?
No, but it helps change things so that police will be deterred and their departments will make sure there's greater compliance, because the financial cost of increasing insurance policies will make an enormous difference in how they regulate and control their police officers.
So if I can understand this, the penalty for not complying with the national standard for use of force is denying federal funding to municipalities. And the penalty for abolishing qualified immunity is that municipalities have to spend more money on defending police officers. So
no, it's their police officers behave better, so they don't
spend a lot more money.
Now, police officers will behave better because insurance motivations work. I mean, they've worked in all sorts of other areas. They should work as well here.
Assuming the police officers cease to have insurance.
Well, if departments actually become uninsurable, then basically a larger entity, so city jurisdictions, for example, can be swallowed into county jurisdictions or state jurisdictions. This has happened in places like Camden, where they defunded the police, but really what that meant is they just, their police department was unsustainable, so it turned it over to the county. And that county has done a much better job. Violence has gone down by police, and overall, it's been a much better situation for everyone involved. Yes, sometimes police departments, if they can't get insured because they're killing and abusing people too much, that's not a big loss. It doesn't mean it becomes anarchy in that jurisdiction.
Well, it would be a big financial loss. But Brian Rubai, I'm assuming we're out of time.
Oh, yeah, you're like 2 minutes over now, so you just keep going there.
Good, that's good. All right. Well, like my friends and colleagues, I wanted to thank everyone for coming out tonight. I especially want to thank the Iowa debate team. During my time there, it was especially Dr. Dave and Paul, but certainly now getting to work with Brian and everything he's done to help us in this debate, we really appreciate. I see jokes in the chat about boxes of tubs. It did not take boxes of tubs. It took about 100 pages of file, all put together by Brian Rubai, and so we thank him for that. I also want to thank the university for the consistent support they've given the debate team. Because one way that I will quickly differ with my friends and colleagues is that not only do I know that I wouldn't be where I am now without the Iowa debate team, I know exactly where I would be without the Iowa debate team. I would be stuck in Shreveport, Louisiana, working as the loss manager at a regional bank, and I would have no level near the intellectual fulfillment and enjoyment in my life. I can say unequivocally that coming to the University of Iowa debate program is the third best thing to happen in my life after marrying my wife and fathering my son. So I appreciate all of you, and I'm very happy to see all of you. And so now let's get on with Just Smoke and Corey. All right. Now, there are 3 reasons why we should not abolish qualified immunity. Abolishing qualified immunity isn't necessary, it won't work, and it will do more harm than good. First, it isn't necessary, because qualified immunity does not protect the police officers who are taking the lives of our fellow citizens. As Corey explained it, what you have to be able to do is show that the police officer violated a clearly established constitutional right, which means they did something that they know they shouldn't be able to do. And despite the fact that American law is a bit crazy in a number of different ways, don't shoot people for doing nothing is actually fairly clearly established. As a result, this is why when we have incidents like Philando Castile, Breonna Taylor, Eric Garner with chokeholds, you have the ability to recover money from those municipalities. Corey's answer to this is to say, well, you settle cases for plenty of reasons. Perhaps you have a good liability defense. I would say the opposite. You fight cases when you have a strong defense so that you make sure that you're not paying out anywhere near what the plaintiff wants you to pay. In the case of Eric Garner, they paid out almost $6 million. Breonna Taylor, $12 million. Philando Castile, $20 million. These are not small numbers to municipalities. They are being paid out because they know they have liability and they know qualified immunity is in a defense. Second, abolishing qualified immunity won't work because, as Corey points out, the municipalities provide indemnification, whether it's through the form of insurance or just paying the cost themselves, and that protects against the need for qualified immunity to spur changes in police behavior. For starters, this is the reason why no police officer has ever thought about escalating a situation or using deadly force, but stopped to think, will this fall under the qualified immunity doctrine? They don't need to have that concern because they know that the police and the municipalities have their back. Police officers are unionized, as Carla said. Their collective bargaining agreements require the purchase of huge insurance policies, which is where they get the millions and millions of dollars to pay out the settlements that we just discussed. Even without those insurance policies, cities defend police officers with city funds. In Chicago, for example, over the past 15 years, the city has paid out hundreds of millions of dollars in settlements and legal fees for police misconduct. According to Daniel Epps, a law professor at Washington University in St. Louis, Chicago proves that high legal bills do not cause cities to fundamentally rethink their approach to policing. And why not? Because cities aren't businesses. They are political machines. Mayors, city council members, district attorneys, as Dr. Dave said, these are elected officials who need the support of police unions to get elected. Thus, abolishing qualified immunity won't work because cities, whether driven by politics, union contracts, or both, will continue to subsidize the cost of police misconduct. Third, abolishing qualified immunity will do more harm than good. We don't deny that America needs a revolution in policing. We need to attract the best and brightest to our police forces. We need to pay police officers more. And we need to have police officers do police work, leaving mental health professionals and social workers to deal with the daily crises that call for help instead of a handgun. To do all of this, we need two things. First, we need good police officers. Ask yourself this question. Prospective employer A tells you that your family must pay for your defense if someone accuses you of on-the-job negligence. Prospective employer B tells you that the company would protect you if someone accused you of on-the-job negligence. Which job would you take? This is not an intelligence test that any rational person would fail. And we want our police officers to act rationally. After all, the more that police officers interact calmly and rationally with civilians, the fewer of our fellow citizens will end up dead. Second, we need money. The essence of both affirmative plans is cause municipalities to spend money they don't have, make the cost of insurance prohibitively high, such that even when you comply with the amorphous national standard proposed by Carla, you don't get any protection from the cost of legal fees and settlements and everything else that would impair the ability of municipalities to bring about the revolution in policing that we really need. There is no need at this time for us to make these minor changes around the edges with the national use of force standard and the abolishing of qualified immunity. What we need is to have our municipalities already struck by the financial cost of COVID to have as much money as they possibly can to revolutionize and overhaul their police departments. That's what happened in Camden. That's what worked in Camden. And that's what we would need to do here. For these common sense reasons, we ask you to vote negative. Thank you. You want some, Corey? You're on mute, bud. You're on mute.
My mute button. That was the whole problem is I have three screens. I have my layout for teaching. Everything just gets a little confusing. I got to play the absent-minded professor real well. Okay, so this last term, the Supreme Court refused to hear a case, Corbett versus Vickers. Police pursued a suspect into someone's backyard. They saw a family dog. They pursued the dog into the house, shot at it twice, missed both times, and shot a 10-year-old child who was just 18 inches away from the barrel gun of the officer. The court granted qualified immunity in that case. How is that right?
Your question is, how is this one particular instance of the doctrine right?
Well, you were doing one particular instances of settlements. I'm saying one particular instance of qualified immunity granted when a police officer broke into somebody's home and shot a 10-year-old from 18 inches away.
If you have the ability to show that the police officers violated the constitutional rights of the citizen before they entered the home, then you have the ability to show that there would have been negligence by the police officer. It seems to me the problem that you're discussing is that even once you get past that constitutional rights issue that qualified immunity focuses on, the police are still given great deference under doctrines you don't address that say that when they feel justifiably threatened for their lives, they have the ability to indiscriminately use deadly force. That's not something you solve, no matter how much you want to try to lay it at my feet.
Well, but the 11th Circuit said the unique facts of this case were different than any other time a police shot a civilian in their home, so qualified immunity exists. And under Pearson v. Callahan, that means they don't even have to decide there was a rights violation, meaning no precedent set for the next time a 10-year-old is shot when they're trying to shoot a dog. Well, I mean, how is this at all an effective rule for controlling or making police accountable?
It's an effective rule in two ways. One is what we're trying to do is make sure that police departments manage their police officers. To do that, we need good police officers. Police officers will not continue to come and work for police departments if they have to pay for their legal defense and their settlements out of their own pockets.
Where are you getting that from? I'd like a cite on this claim that police will not work for departments that have bad raps and basically for brutality. I mean, why would we ever?
I wouldn't say not working for bad raps. What I'm saying is that if you put someone in a position where they have to pay the cost of defending themselves, the cost of doing that is greater than whatever the salary, benefits, et cetera, are for the job.
So this is only true in a circumstance where they do lose the insurance policy, which no police department ever has. The Chicago example you use, that's a self-insured city. They don't actually have insurance policies. So, I mean, I don't even understand.
I mean, if you want to walk around into the plan, meet, need argument, we can do that. But as long as people have the ability to obtain indemnification, then you aren't going to solve the problem. You're abolishing qualified immunity just says let municipalities get sued a lot more. The idea is that if they get sued a lot more, they'll do a better job. But that's not their incentive. Their incentive is to protect their police officers.
The department doesn't care at all. You know, so when Chicago loses, I mean, how are you not contradicting yourself? On the one hand, you're saying cities won't care because they basically are infinite budgets because they're municipalities and not businesses. And then on the other hand, you're saying, oh no, the cities are going to lose all this money and it's completely, you know, going to undermine their incentives for better policing. I mean, I don't even know what your story here is on the financial incentives in this anymore.
My story is that the threat posed by the affirmative is to cut off funding, whether it's through the use of the federal funding from the National Standard for Sports.
Yes, it's a common incentive system.
Thank you. Carrots and sticks. Can you educate me more that you learned in your 9th year of college?
No, we ran out of time, and we just don't have enough to get into that level of detail to help you out here. So I think we got to move on. We got to move on. I'm sorry. The time is up.
So that was the final cross-examination of the debate, and we now go into the final two speeches, which can be 4 to 5 minutes. Each side gets one speech, and they can have a little bit to prepare here for their final remarks. But what's a little bit different than a policy debate is normally in a policy debate, the affirmative team or the pro team would speak last. In this case, the pro team, Corey and Carla, are going to speak first. And so whenever they're ready, they'll give their final address, which will be 4 to 5 minutes.
I got to tackle all the issues here. It's tough for me to decide which Andy is more wrong. The simple fact is, policing is become a major problem in the United States, is seen as protests across the country. There is little doubt that policing in the post-Ferguson era is an important and salient issue, but it's also important to note that what is shaping our discourse here and about how to deal with it is, you know, we can either have the Andy Ryan talk around in circles, contradict yourself a few times about financial incentives, or get rid of a doctrine that prevents bad cops from being punished. I mean, it's a pretty simple, straightforward approach. A national force standard isn't going to be perfect, right? There's going to be needs for adapting here and there, but everyone agrees chokeholds are awful. Right? This has been a long-term, easy thing. They kill people. They serve no positive function. A sleeper hold, where you cut off the artery, is at least arguably defensible. But chokehold, cutting off the airway, is just inhumane, and it risks death. And we've seen these patterns over and over and over. And this, you know, whether you listen to Andy's, or I keep calling them both Andy. Okay, AP or ARI. If you listen to AP's claims about the need for localization and fine-tuning here, he's simply trying to make the perfect be the enemy of the good. We have had no proactive federal action to deal with policing in decades. Every attempt, including those that were supported by Joe Biden in the 1990s under Clinton, have been to fund police more, to give them more money so that they can militarize their police, get the cool new tank, and brag to all the other police departments about it. I mean, look at the protests and the way people are responded to now. We have armed soldiers in our midst. And what qualified immunity does is it protects them entirely from any civil accountability, and it protects their department. And this is where ARI has got the incentives all messed up. Departments have no incentives to train de-escalation, to train better cultural awareness, to train dealing with mental illness in a world of qualified immunity, because they just let it go. What you need to do is have some liability here, and this encourages the education function within police departments. And we've seen a decline across the country in how much police are even attempting to train their officers in these situations. Justice Sotomayor, in her dissent in one of these cases, I think described qualified immunity the best. It's about shoot first, think later. Right? That's the doctrine and the incentives that it gives to police. A national force standard helps supplement the removal of qualified immunity by setting a baseline, right? It's just about setting a floor, not a ceiling. It's saying these are the things that are off limits. If states want to go and find other things to restrict, but we just can't have a system here where police can say, oh, I thought I saw a weapon, and that's enough. That's pretty much ends the discussion. Or, as many of these qualified immunity cases illustrate, they just find a new and different way to deny somebody their constitutional rights, even including shootings. And the courts, say, oh, well, that's a little different because Pearson v. Callahan says that's the case. And I mentioned the example in cross-examination to ARI, that was one case this term. Another case the Supreme Court decided not to hear, Baxter versus Bracey, concerned a suspect who was sitting on the ground with his hands raised, surrendering to the officer. The officer sicked the police dog on him. And the court here said, well, we're going to give qualified immunity because even though there's prior precedent that said when a person's lying on the ground and surrendering, you can't sick a police dog on them. In this case, they were sitting up. I mean, that's insane. This doctrine is indefensible. Ask yourself a very basic question, which is, if you were brutally beaten by the police without justification, or a close family member was, would you think it's right that the officer and their police department escapes all liability, right? They're not going to be held accountable in any way. This idea of repealing qualified immunity and having a national force standard, it's not about punishing cops. It's not about bankrupting departments. It's about holding them to a basic standard of professionalism and human decency. It's about ensuring that our fundamental liberties that are outlined in the Bill of Rights are protected. To those ends, qualified immunity has to be eliminated, and we have to set a baseline. States and localities have failed for decades. They have not even attempted to rein in against powerful police unions, and it's just these are basic facts. And there's not going to be any worries here about frivolous lawsuits. There's not going to be any worries about police here, because qualified immunity only kicks in the situation where someone has already had their rights violated, or in some cases they're killed and it's their estate bringing the lawsuit. And the simple fact is, all that repealing qualified immunity does is gives more plaintiffs their day in court. It prevents the case from just being dismissed out of hand. It gives them a chance to present to 12 civilians their arguments, and police can defend themselves. And a national force standard is just basic information to say, don't do this, don't do a chokehold, don't shoot unless you have better confirmation than a vague 911 call that says there was a 12-year-old boy at a park playing with a gun. When they shot and killed Tamir Rice in Cleveland, the police officers drove up while the car was still rolling, and within 2 seconds, they shot and killed a 12-year-old boy without confirming any danger. No one else was around. Qualified immunity and an absence of a national force standard are what empower police to do this and prevent effective training in departments across the country. We need change, and we need it now.
Thank you so much. And for the final con speech, we gave about an extra minute there at the end, so feel free to take about 4 to 6, anywhere in that range.
Thanks, Brian. Look, we agree that we need change and we need it now. We disagree that your change is the right change. When we all work together to put together this resolution and to choose the 2 issues that we talked about, we didn't choose to go negative because we were cold to the incidents of police violence that are rampant throughout the United States. We did it largely to be fair to our elder friends. But primarily, we also think that there are central problems in the resolution that we haven't addressed. The first is qualified immunity. The problem with qualified immunity is you present it as a question of making sure that bad cops are punished. But bad cops are punished now. Abolishing qualified immunity will also result in good cops being punished, because the level of punishment that you're talking about is defending yourself through a lawsuit, a process that has significant financial costs, significant personal costs, significant reputational costs. And Corey's argument against this depends upon having faith in lawyers. And as a lawyer, let me tell you, there is no need to have faith in lawyers. We are all godforsakenly terrible. Corey suggests that if there is no standard for negligence, that there won't be frivolous lawsuits that will be brought. Are you serious? Drive through your hometown and think about every billboard you see that says car crash ? You're going to have that with every instance of police brutality if you make it that much easier to sue police officers. His only response to that is to say, but those officers will be indemnified by the cities for which they work. Right, which is why there won't be an incentive to change. When you're talking about the idea of there must be so much liability, so much exposure to prevent the need for cities to get insurance, you can get insurance for anything. Again, this is a common sense point. No matter how much they make the cost of health insurance, we will buy it for our families. No matter how much they make the cost of insuring against police misconduct, cities will buy it for the police unions who demand it, which means that abolishing qualified immunity will not have the results that Corey wants it to have. Second, the national force standard, our objection here is that the definition of insanity is doing the same thing over and over again and expecting a different result. What Andy Peterson has laid out is that since the 1960s, through effectively every president, we've attempted to argue for a national force standard, and it has not worked. Even if we succeeded in getting a coherent standard put together, which one wasn't proposed, even if we succeeded in getting it implemented, which would have a lot of problems for the primary reason that Carl has identified, which is the existence of police unions, we would still have the problem of getting police officers to comply with it. There are cities that have banned chokeholds, and the officers that don't want to comply with that still choke people to death, which is what happened in New York. The existence of a standard does not mean the compliance with a law. It means that the law is written on the book somewhere. And if you need any better evidence of that, think about the fact that police unions have lawyers who advise them on every single Fourth Amendment and Fifth Amendment decision that comes out of the Supreme Court, so that they are told what it is they can do and still successfully violate the law. You are fighting a behemoth, and you cannot do it by putting words on a piece of paper. You cannot do it by eliminating a doctrine that they only use 2% of the time anyway, and you can't do it in the way that's been proposed by the affirmative. The worst thing that could happen here is putting municipalities in the situation of not having enough money to address the problem we need to address. We need a revolution in policing in America. To do that, we need money. We need support for social services. We need support for mental health professionals. We need support for the good police officers that don't commit the types of actions that have resulted in the deaths of these individuals. So putting together a plan whose two components are impose financial strain on municipalities is a bad idea. That's why we've never opposed the idea that we need change in policing. We just oppose the idea that what they've proposed will work, and it won't. Also, I've just got to say it, I think we all need to take a poll at the end, because we all know Corey was making up some of those Supreme Court cases, right? We're all certain of it. Just like 1,000%. No? Okay. Now, look, in all seriousness, we say that the A. Craig Bear debate forum is on the side of truth. And the truth here is that unions are large, enmeshed institutions with substantial political support in the cities in which they operate. And we can't go at them with what amounts to the legal equivalent of a gnat. We need to go at them with a bazooka, and we need to provide support to take away from them the powers that put them in the position to hurt people. And to do that, we need money and we need good police officers. And both aspects of the proposal make that harder, not easier.